Iain has been a senior fellow of the Ronning Center for a few years. We've done some things together in the past, and Iain, one of the reasons I appreciate him so much, I suppose, is that his instincts led him down a pathway to get a good education. So he began studying literature, and then shifted to philosophy, and then to theology, and then to law, all in an effort to find a way to get a decent education in university. So Iain's published widely. There's one of the Ronning Center booklets is his booklet on that you may be familiar with. Some of you will no doubt have read, Living Together with Disagreement. You did your PhD in South Africa and your law degree in Cambridge.
Was the first one.
So his work as an academic, as a lecturer, and a practicing lawyer is focused on constitutional law and human rights, with a particular emphasis on issues of religious liberty and the nature of pluralism, and what in Canada we sometimes call multiculturalism, and the relationship between law, religion, and human rights. This is a very controversial area in which the way things often get defined or appear to be defined is not even half the picture. Iain has been before the courts at various levels, including the Supreme Court of Canada, on such cases over the years. So my sense, I often say to people when I introduce Iain to them, that even if you disagree with him, you ought to get to know him, because you're going to refine your thinking and your ability to deal with these matters. So he was invited to become a senior resident visiting scholar at Massey College at the University of Toronto recently. And he is I love the title, a professor extraordinaire at the University of the Free State in Bloemfontein in South Africa. Iain was a central person in the drafting of the Charter of Religious Liberty.
Religious Rights and Freedoms.
Religious Rights and Freedoms in South Africa.
Yeah.
First country where they've done this. And he's a bit of a peripatetic scholar, living in, when he's there, in France.
Mm-hmm.
I wonder how far he is from you people. Where are you?
We're down near Montpellier.
Oh, I'm on the other side. I'm in the Haute-Pyrénées near Lourdes,
Okay.
between Lourdes and Pau,
It's not terribly far. We're
on
in
the
south.
Spanish border.
We're in the south by
Mm-hmm.
Midi.
So, works in Canada, South Africa, and a number of other countries on a variety of things. So I'm delighted he's here with us again and talking about the Trinity Western Law School, something that I've been thinking about a bit, talking to people about, so I always like to have a chance to hear Iain on these things. And then this afternoon at 3:15, as you may know, he'll be giving a lecture in the class that I have over there. And that has been titled,
What joins, what divides, and who decides?
yeah, so we'll be looking at these issues in a
Looking at
somewhat different way.
pluralism, the common good, and the limits of law.
So, the Trinity Law School case.
Yeah. Is everyone familiar with the Trinity Western case, or do you want me to quickly go over the... Okay. The most recent developments are involving a challenge to the university's desire to found a law school. But the Trinity Western case itself, the first one, emerged in the late 1990s and was decided by the Supreme Court of Canada in 2001. in a case called Trinity Western University and the BC College of Teachers. And for those of us who followed this current debate about the law school, it's entirely deja vu to the events of late 90s and early 2000s, when the BC College of Teachers, the body statutorily empowered to determine whether education program was sufficient to be accredited, rejected Trinity Western's education program on the same basis as the issue came before the Law Society, namely that their community covenant, which restricts certain behavior of students and faculty on the evangelical campus of Trinity Western University in Langley, British Columbia, they said made the atmosphere inconsistent with the principles of human rights and openness that need to typify British Columbia society. The education case, their refusal to grant permission to the final year program of Trinity's education courses, went to the courts and was fought all the way up to the Supreme Court of Canada, where they issued a decision against the BC College of Teachers' decision not to grant them accreditation. They ruled that Canada has many universities that were founded on religious principles, and they list a whole bunch of them. And the fact that there's a religious ethos is part and parcel of the freedom of religion. And there was no evidence before the court of any particular discrimination against gay or lesbian students. Now, I should say that the community covenant covers quite a few different matters. I've got it in front of me here. In its recent form, it was reworked after the initial decision, but not in ways that I think are key to the current debate about the law school. But the key thing is this: their statement that in keeping with biblical and TWU ideals, community members voluntarily abstain from the following actions: communication that is destructive to community life and interpersonal relationships, including gossip, slander, vulgar, obscene language, and prejudice. And each one of these propositions contains biblical verses supporting it. Second, harassment or any form of verbal or physical intimidation, including hazing. 3, lying, cheating, or forms of dishonesty, including plagiarism. Next, stealing, misusing, or destroying property belonging to others. Next one, the key one for the moment: sexual intimacy that violates the sacredness of marriage between a man and a woman. Next one, the use of materials that are degrading, dehumanizing, exploitive, hateful, or gratuitously violent, including but not limited to pornography. Next, drunkenness, underage consumption of alcohol, the use or possession of illegal drugs, and the misuse or abuse of substances, including prescribed drugs. Next, the use or possession of alcohol on campus or at any TWU-sponsored event, and the use of tobacco on campus or at any TWU-sponsored event. Okay? Well, what's obviously attracted the concern of the current debate is the provision primarily dealing with sexual intimacy that violates the sacredness of marriage between a man and a woman. But in what I'm going to discuss, I want you to note how the blanket restriction on sex outside of marriage, which affects heterosexuals as well as same-sex sexual relations, is entirely recharacterized in the public debate as a ban on gay sex, when in fact it's a ban on all extramarital sex. But the lens through which this debate is being focused is entirely, and you'll see it culminates fascinatingly in a statement from the president of the Law Society of British Columbia just weeks ago, as a conflict between the freedom of religion and equality. Now, for the president of the BC Law Society, who's a QC, to accept that characterization is legally incompetent. Now, I say that, I know this is being recorded, and I say that with respect, but the level of our collective cultural confusion about the principles that are at issue is so deep and so serious that even the president of the Law Society of British Columbia does not understand the mistake she's making. Why do I say that? Because in the Canadian Charter of Rights and Freedoms, Section 2A, which protects conscience and religion, and the various provisions of the Constitution that deal with the rights of freedom of association, which is also involved in this case, is one set of framing of fundamental rights. Section 15, which is the non-discrimination and equality provision, includes a whole list of categories, including religion. Now, if you can't be discriminated against on the basis of religion because it's an equality right, how can this issue involving Trinity Western be properly characterized as a debate between freedom of religion and equality, when religion is an equality right itself? This basic confusion about the structure of the Constitution and the relationship between the rights within it at the highest levels of the legal fraternity, the legal establishment, shows the extent to which we simply do not understand the core principles of the Constitution in Canada. And it goes right the way, not just from lawyers, but to the bench. Justice Willard Esty, at a conference I attended in the 1980s at UBC, said, "You are asking the judges," this is just after he retired from the Supreme Court of Canada. Some of you may know the name Willard Esty. He said to this conference, "You are asking judges under the Canadian Charter of Rights and Freedoms to answer questions we have not been trained to deal with." Okay? Now that's really important because nothing has changed. In fact, what's happened has been a series of seminars, many of them done by constitutional experts, people interested in human rights and the Charter, who are themselves very badly educated in the nature of a plural society. What we have is a set of rights debates in Canada, argued by advocates of one side or the other, that pay very little attention to the nature of diversity as a whole, and very little attention to the rights and freedoms of religion as an equality right. So everything's asymmetrical. It's being rammed through by activists and with scant regard to the idea of how you live together with disagreement, which is the title of, as David mentioned, the monograph that I was asked to write for the Ronning Center. So the BC College of Teachers, all those years ago, its decision was struck down. The head of the BC College of Teachers at the time was a lesbian. And she was very focused, as gays and lesbians often are, on the recognition of their identity. Their identity recognition and its affirmation is central to all of their understanding of culture and their claims about rights. You need to understand this, that their quest for identity recognition is relentless and grounded in valid claims of rights protection. Nobody who has any sense of justice can oppose some of the protections that have been put in place for gays and lesbians in Canadian culture. I've run into people in the United States who say there should be no recognition for gays and lesbians in terms of legal protection at all, a proposition that I think is monstrous. So the question then is, what are the limits? Because no rights are unlimited. The right to religion is limited. Otherwise, we wouldn't be able to restrict female genital mutilation or things like cannibalism, which have all been argued for in various areas as religious rights. Clearly, we don't accept those things. So the difficulty is demarcating the line between acceptable and unacceptable religious practice. And what this involves is an understanding of the core moral principles that have to undergird the whole society. Now this brings us to sex. Sex is something about which reasonable people disagree. Not at the margins. We don't allow sex with children. We ban that under the criminal code, which has been understood as a rough and ready moral code by the Law Reform Commission of Canada and its work in the 70s on the nature of the criminal law. So certain things we're going to ban. Certain things were banned, like gay sex. Pierre Trudeau, in bringing in the omnibus bill that allowed consenting sexual acts between adults, said the state has no place. Where? All together now? In the bedrooms of the nation. We all know this. But a few years after that pronouncement, justifying the change in the law on sodomy and so forth, we saw gay pride parades in the public sphere, and we saw a mayor who didn't want to proclaim a gay pride parade in Ontario, Diane Haskett, in London, forced to proclaim a gay pride parade in the public sphere. I mention it simply to point out that if the state had no place in the bedrooms of the nation as a justification for same-sex conduct, how it moved to the state had an interest in the gay pride parade in the public sphere. So something had changed. The private-public distinction is in play in interesting ways. I'm not making a judgment on that except to point out that that's the shift that's occurred. And it's relevant to what's happening at Trinity. Because there, the claim for same-sex recognition is being driven inwards to a private association. This is a private university at Trinity Western. That private university seeks to do something. It seeks to have a publicly accredited law school. So while it wants a private atmosphere, a religious ethos that the covenant speaks to, it wants public recognition for its legal faculty in the same way it sought and achieved public recognition for its education faculty. Now, lawyers are supposed to understand certain principles, one of which is precedent. The way precedent works is that the rulings of a higher court are binding on a lower court. And even between decisions of a lower court, they're supposed to be they're supposed to be weighed very seriously by a court of the same level. But a higher court binds lower courts. Now, obviously, sometimes there's an interpretation. Is this set of facts similar to the one that the higher court passed judgment on? If not, then maybe there's principles that can be applied that allow the narrowing or different application of the higher court judgment. But in Trinity Western University, as one of the senior lawyers pointed out at a public meeting that was held for all the lawyers to debate the question, the Trinity Western decision of 2001 is on all fours in all relevant respects. Same party, Trinity Western, same or virtually similar covenant, statutory review mechanism virtually identical for the Law Society and the College of Teachers, issues of concern to the culture the same. And what happened? The lawyers who wanted the Law Society decision to be different than the College of Education decision argued that times have changed, that there's a kind of winds of change have blown through the hallways and should lead to a different legal decision. Well, the old lawyer who spoke from his wheelchair at the microphone was shaking with anger as he shook the Trinity Western decision in 2001. And he said in the large conference hall that this meeting was held at in Vancouver. I know this graphically because I was standing behind him. In fact, I gave up my place at the microphone so that he could speak. And what McAlpine, that's his name, said was, don't you people across the room voting against Trinity Western's right to have the law school understand how to read a legal decision? This is law that the Supreme Court of Canada passed, and you're brushing it away as if it's nothing. You're supposed to be lawyers, he said. Now, it wasn't just a radical group of largely young lawyers who stood at the microphone arguing against Trinity Western. It was, in fact, 75% of the lawyers who voted in the biggest turnout in the history of the Law Society of BC, when it came to a referendum later, voted against Trinity Western University.
Can you just say briefly why it came to that? Like, what is the Law Society actually doing?
The Law Society, okay, the internal debate is important. I'm glad you raised that. I don't have time to go through this in the detail that would be necessary to really make it crystal clear for you, but there's different levels of responsibility in relation to law school accreditation. There's the Law Federation of Canada, there are the provincial law societies, and the federation has the ability to look at certain things in the law school program that's proposed. But ultimately, it's for the benchers of a law society provincially to determine, to accept the recommendations or not of the law federation. There's also other players who are influential in the legal world, including the deans of law schools. Now, the deans of the Canadian law schools wrote to the Federation of the Law Society and said, we know that you have before you an application from Trinity Western, and we're very concerned about that. And they wrote a famous letter in which Flanagan, the dean of Queen's Law School, himself an out gay person, wrote and said they, the deans, opposed the application of Trinity Western. The Federation got legal opinions and determined that the Trinity Western decision of 2001 in fact was relevant, and that there was no proper basis to oppose Trinity Western's program. But the letter from the deans is really interesting because it mischaracterizes the covenant that I just read to you as being about the restriction of gay sex. That it selects gays and lesbians out for invidious discrimination when it does nothing of the sort. The letter was put before the Federation of Canadian Law Societies without a single dissenting voice from a Canadian dean. Every Canadian law school dean was deemed to have been in support of that letter. Now, I wrote an article called Law Deans, Legal Coercion and the Freedoms of Association and Religion in Canada, which was published in the magazine of the Law Society of British Columbia, in which I basically called out the deans for sleight of hand and intellectual dishonesty. Not a single dean responded to that article that was published. So we have a very unusual situation in Canada. We have Peter Berger, the famous sociologist, wrote a very interesting article on secularization. And he said that the secularization thesis, which is that religion loses relevance in culture over time, and eventually religion ceases to be of significance through secularization. That thesis, very popular in the 50s and 60s and 70s, was actually wrong. Religion stays very important to culture, and indeed, as we see around the world, it's of increasing importance in societies. He says, except in two areas: the media in the West and the higher reaches of the legal establishment. Their secularization is deeply, has a deep hold. Now, what does this mean? I think it means that the law itself, in terms of its administration, has a lead ear or a tin ear when it comes to issues involving religion. It doesn't know how to deal with religion, which is why you can get the president of the Law Society saying the issues between equality and religion, which is clearly wrong on the law. It's why you can get the law deans of being afraid to raise issues of diversity in relation to religion and being led by the nose by someone who's got a particular interest in the issue. Now, this is not an encouraging thing for those people who believe diversity involves respect for all kinds of communities. It's not encouraging for those who think that having fought a decision all the way to the Supreme Court and achieving a legal victory means something over time, to see that a decade later it can be rolled back. And they're going to have to do the fight all over again. It's not encouraging to see the lack of respect for religious associations' views on sex. Because at the core of this debate is really that central conflict I mentioned at the beginning between the identity that is being sought by gays and lesbians and transsexuals and all the group that now is under that broad category. Their quest for recognition, i.e. acceptance of their sexual conduct, against the religious viewpoints which have particular views about sexual conduct that the gay groups don't agree with. They don't like the religious view of sex. the religious people don't like the gay view of sex. So we have a cultural conflict about sex. So what else is new? Disagreements about sex and conduct about sex are in virtually every family when the parents talk to the children. Some parents may not care what their kids get up to, but a lot of parents want to set down rules about what is appropriate and inappropriate, rules about dating, about dancing, about clothing, you name it. Similarly, in associational life, how we live together in our groups, in religions, or in our communities, there's different views about what is acceptable and unacceptable. But somehow, our society has been led to start thinking that under the rubric of sexual orientation, i.e. what your desires are, there's a right to the fulfillment of the desires. And that to interfere with that fulfillment of the desire creates a right that needs to be enforceable by law. So let me repeat that. If sexual orientation is protection of the category of what you desire, then the context of where that desire is going to be operative is surely relevant to our assessment about the claim for sexual orientation protection or advancement. And I don't believe that that central conflict is being properly addressed. So what's happening is,
Say it one more time.
homophobia is the term that's used everywhere. If you don't agree with gay sex conduct choices or lesbian sex conduct choices or transgendered sex conduct choices, and you or gay conceptions of marriage or lesbian conceptions of marriage because your tradition teaches that marriage is male and female, you are called a homophobe. And no one wants to be a racist with respect to race, and no one wants to be a homophobe with respect to sex. But what does it mean to be a homophobe? Well, it can be a spectrum of things. But what that spectrum has roped in is this kind of distinction that Trinity Western is trying to make, where they're saying they believe the biblical precept is there should be no sex outside of the sacred bond between men and women. For heterosexuals as well. One commentator said, well, Trinity Western must be the horniest university campus on earth if neither the heterosexuals nor the homosexuals are allowed sexual expression. Well, that was the Globe and Mail, so perhaps that, we take that with a grain of salt. But the point is, the disagreements about sex are being turned into a kind of racist analogy. You're deemed to be like equivalent to a racist if you don't agree with all forms of sexual conduct. And that is quite an interesting, but I think bizarre analogy. I don't think that the disagreement with another person's sexual choices equates to a rejection of the other person. In racism, a disagreement about the person's status as a human being because of their race is a complete rejection of the person, different from a rejection of the person's sexual choices. Like the rejection of a person's religious choices is not deemed to be equivalent to racism, but a rejection of their sexual choices is. You see? So there's a kind of false argument at the core of homophobia articulations that is now culturally dominant in Canada. And it's clearly exercising an influence even in those areas of culture like the law that should be able to make more nuanced distinctions, but seeming capable of it in the face of this driving quest for recognition that's emerging from the same sex, from the sexual orientation advancement community. I don't even know what to call it properly, but we can call it sexual orientation advancement. So, the claim that your viewpoint, our viewpoint, any of us, on sex or religion should be the case for everyone is not a claim, a liberal claim in a free and democratic society. William Galston, the American political philosopher, calls it civic totalism. It's the claim that my view on sex should be the same, everyone should accept it. That's a civic totalist viewpoint. And I think it's a helpful term he's come up with there. Because in the same way as we rejected theocracy, being the view that the state should be pushing one religion, we now have a kind of sexualocracy, a kind of sexual rightsocracy, in which if you disagree with my view of sex, you're like a racist. We know the state doesn't want racism, but now under that clever sleight of hand, which is actually dishonest, where we've roped in sexual debates to racial debates. And I think that we have to decouple in order to have a proper, a sensible approach to this issue in Canada. We're going to have to learn to decouple some of these claims. They're not actually valid claims the way they're being argued. Yes, everybody's due respect for all of their beliefs, but the disagreement about beliefs does not constitute a discrimination that should have a legal response. In the same way as we can disagree with a person's religious choices without rejecting the person, we should be entitled to reject their sexual choices without rejecting the person. Do you understand the parallel there?
Yeah.
But
I think some of the people that we're talking about in the religious people reject you as a gay, period. It has nothing to do with, if you're a gay, you're a bad person, you're rotten, etc. So they reject at that level even before they get to the sexual level.
right, which is,
That's a part of the picture too.
I think that's true, in the same way that other people can reject a person on their religious or their racial grounds entirely before we even get to what they are as a person. So
Yeah.
there's an analogy. I mean, I know I come out of a tradition in which I had a grandmother from Northern Ireland, and she disliked Catholics. Catholics were this and this and this and this. So these kind of unnuanced categorical rejections are a real problem, and you're right to point out the rejection of people because they're gay. So what we have to try and do is create a culture in which other people are respected for who they are, but allow space for the distinctions, the moral rejections or acceptances that a properly informed culture should allow. So Trinity Western, in my view, I'll just tell you my position, that pluralism and diversity should allow Trinity Western to have a law school. Their competence has not been questioned by the people who have been granted the authority to check out the curriculum, the staffing, the facilities. They've got a good library, they've got a sufficient staff, they've got an adequate program to teach law. The BC Law Society benchers, who are the people given the authority to determine that in the province, voted in favor of it. They got legal opinions, and they decided to vote in favor. But then a card was played to put it to a referendum of the membership. And that's when the emotional floodgates burst. And everybody jumped into the homophobic kind of articulation, the overbroad claims, and Trinity Western's now being rejected by the Law Society of BC. And as I said, with respect to the president, it's been rejected on the wrong basis. Namely, that here we have a conflict between equality and religion, and equality should succeed. Well, religion is an equality right, so that's a bad approach. Now it's going to go to the courts, and the courts will have to decide.
Which court does it go to?
Well, it'll start off in the provincial, well, I didn't mention this. Trinity Western, because it's seeking accreditation for its graduates across Canada, but the law societies are provincial jurisdictions, has now had its accreditation challenged in several provinces. So what's happening now, there's lawsuits going ahead in Nova Scotia and in Ontario whose law societies have rejected Trinity Western's application. BC had accepted them and now has changed its mind. So this issue's significant, but I want to pull the lens back in concluding now, because I think I've said enough, and say this. What Trinity Western shows in the 2001 decision and the current debate, which is still, it's happening right now. It's going to go into the courts in December, it's being argued, in British Columbia. What this is deciding is the scope and nature of religious diversity in Canada and the nature of our pluralism as a society. How do we live together and tolerate those who have viewpoints with which we completely disagree? That's what's at issue. And at the moment, I'm not very encouraged by the quality of the debate and the discussion. It's highly driven by ideology and emotion, and there's very little analysis being given to the core issue about whether people have an entitlement to disagree about sexual conduct. And no one wants to admit that at the core of this is a debate about sex. And on that, I'll conclude, and we can have, I hope, a good discussion. So thank you.
Thank you. So what do you think?
Well, the
Iain sees this as an example of a kind of movement in the country, which is a movement fundamentally against pluralism.
But the fact that I believe the Canadian government now permits marriage between same sex, and in their covenant it says restricted to only marriage, sex within marriage between a man and a woman. Will that change anything?
No, the Civil Marriage Act that emerged from the reference that was stated to the Supreme Court of Canada expressly allowed for, in its preamble said that whereas Canadians have different views about the nature of marriage, it allowed same-sex couples into the category of marriage, but it didn't do the next step, which was to require all other communities to accept same-sex marriage. This is a huge, important realization. The context for Canada is one in which you can have associations that disagree about the nature of marriage. In the same way as you can have associations that disagree about other things that are not allowed in more public settings. For example, you can have gender discrimination in relation to religious offices, like the priesthood in Catholicism, or Judaism has synagogue congregation rules based on gender. All religions have different views about the nature of their elite offices. You can't be a married man and be a priest in Catholicism, and yet the Human Rights Act preclude discrimination on marital status. How does the Catholic Church get away with restricting married men from being priests and women from being priests? The answer is Human Rights Acts exempt religious associations from those kind of general discrimination provisions. Now, you might argue, some do, that these kind of historic protections for divergent viewpoints allow islands of discrimination to continue to exist, and the sooner we get rid of those differences, the better. But be careful, there's a sting in the tail of that, and that is that if you homogenize your culture by getting rid of distinctions, you decrease the capacity of people to choose how they want to live. In other words, if you come out of a particular religious tradition with a view about sex and marriage and so forth, that doesn't comport with this new developing liberal attitude, you're going to be unable to maintain that if all the laws wipe out the diversity of your community. Now, if you're on the side of doing that, getting rid of differences in these areas, then that doesn't trouble you. If, however, you view the differences of communities and the ability to choose between them as important to human life and community life, then you're going to be concerned about this development. So it depends on how you view culture, whether or not you're concerned with these developments.
I recall having a conversation many years ago in the context of the United Church around the issue of gender and priesthood. The United Church, of course, had opened the possibility of being ordained to the ministry back in the 30s, I think, fairly early, although it didn't do much of it until the 70s. But the people that I was talking to were really on the side of that whole issue of let's make things equal across the board in all cases, and the attitude of the Catholic Church and of the Orthodox Church are ridiculous. But the odd thing about the argument is that at the same time, they were interested in supporting the distinctive cultural nature of First Peoples. Well, the sting in the tail is, if you want to do that to Christian churches, then you're going to have to do it to tribal peoples too. And if you want to find a place where gender is really significant, it's in cultural communities which are ancient and where the elemental role of gender symbolism is still very much alive compared to how it has been in Protestantism. So the sting in the tail is certainly there, but it's always amazing to me how easy it is for us to see the issue only here and not see it in another place and realize what the implications would be.
Yeah, it's very important in law to realize that the way you develop a test has applications in many different areas. In that Civil Marriage Act, federally, because recall under the BNA Act in the 19th century, marriage was divided between the feds and the provinces. With the sacramental nature of marriage, it's sort of how it was to be administered was provincial. But the capacity for marriage, whether it was two people of the same sex or a male and female or one or multiple marriages, that's the federal jurisdiction. So we've always in Canada had a recognition of the solemnization of marriage being the provincial thing. Now, interestingly, when the Marriage Act came in, it expressly allowed religions not to marry not to marry same-sex couples. Religious officials are expressly protected. By parity of reasoning, religions that want to teach their own views of marriage, like Trinity Western, I think should be protected to do so. One of the consequential amendments to the Civil Marriage Act was an express change to the revenue legislation, the tax legislation, to make it so that charities that advocated heterosexual marriage were not to be threatened in terms of their charitable status because they continued to maintain heterosexual conceptions of marriage. Why was that necessary? Because at the time that those of us who appeared before the Justice Commission or the various federal bodies reviewing the marriage legislation, at the very time we were appearing in Ottawa before those committees, groups of activists were going public saying they were going to challenge the charitable status of religious organizations if they didn't accept same-sex marriage. So these groups are very careful, very clever at nipping off the ability of projects they disagree with to raise funds or maintain their activities. And this, some have used the term, I don't like it because I don't like the militaristic terminology, but they refer to what we're involved in as culture wars. And but I do think that there's a real failure to live and let live in Canada and in a lot of Western countries. The idea that other communities can maintain their distinctive, eccentric, bizarre, or even views that we dislike, the idea that we need to find a way to coexist with different viewpoints is under threat from the idea that we need to get everyone to change to what we think is the right way. Civic totalism, that idea that everyone must believe what I believe, is the dominant modality of many human rights activists. They do not believe in live and let live, which scholars such as Stephen Macedo have said are key to the proper approach to liberal society. So we have a struggle between how we understand liberalism itself. There are some that view it being a move towards convergence where everyone's going to believe the same kind of things and tolerance is just a means to get us to agreement, and those who believe that we need to find ways of living together with disagreement. I'm one of those. I think we need to stop trying to force everybody to believe what we do and allow people to have their choices.
Does Trinity accept any public funding, or is it simply totally private?
It's private, but I don't think it would matter if they did accept public funding, because I'll tell you why. The distribution of public funds, to my way of thinking, needs to be equitable across the culture. It shouldn't be just restricted to those who hold particular viewpoints.
But if a couple were married and then applied to Trinity and they said, you can't come here because you violate our charter, and they say we're legally married in Canada, and the institution was accepting public funds, then I would have a problem with that any institution accepting public funds should accept Canadians that are living a legally sanctioned life.
Yeah, well, that's an argument. That's an argument that will be made.
I had a conversation with somebody who was very close to the senior administrative people at Trinity. And even though they can't drink at Trinity, they can drink scotch at their homes. So
Well, the
in the
public
quiet of the night, they had this conversation and this issue was raised. And this particular person, a very high position, said he really didn't know what he would do about that.
But
So
But the
you can rest
marriage,
assured,
see, the
it'll happen.
marriage law itself recognizes the disagreement and context. So there's a tension right in the very law that was brought in as to how these matters will be resolved. And I don't think they're easy. But I don't like the public funding mousetrap. You receive public funding, therefore you have to do everything. I don't buy that. I think the public funding dimension, if we're not careful, plays into a kind of secularism, which is the idea that the public sphere is stripped in all respects of any religious influence. Okay? Now, I don't like that, because I think, and that's in tension with our understanding of the essence of the freedom of religion from the Sunday closing case, Big M Drug Mart, in which Chief Justice Dixon said the essence of the freedom of religion isn't just the right to hold a religious belief in private, but the right to teach it, manifest it, and disseminate it. Well, what are those things? Teaching isn't just private. Manifesting clearly isn't just private. Disseminating shouldn't just be private. In a free and democratic society, manifesting involves things like picket lines, the right to protest, the right to be out there saying what you believe in appropriate ways. Disseminating. You know, we know of cultures where dissemination is driven underground. You know, samizdat in the Soviet Union was the distribution of ideas and viewpoints secretly.
Saudi Arabia.
Well, France too, because
France.
France has disallowed Muslims to wear headscarves in schools because
Yeah.
they're publicly funded.
This allowed everybody, you see. You can't wear a yarmulke in a public setting in France. You can't be employed by the
You can
post
wear-
office,
You can wear a cross though.
only if it's very small.
Yeah,
Yeah.
but I mean, it's still, to me, that shoots their argument down. If it's religious symbols, I think the reason that they did that was because of Muslim headscarves.
I think that's a good point. The point, I hope this is is this picking up the sound everywhere? Islam is the elephant in the room in a lot of these legal debates. It may, on the surface, involve a Jewish issue or a Christian issue, but what's really in the back of a lot of people's minds is Islam, because they're really afraid of the Islamic incapacity to assimilate, or they may be afraid of what they perceive to be the Muslim aggression against other communities. And what these immigration patterns have done is they've forced us now to start considering how Western principles are engaging with non-Western principles. And it's not an easy engagement. So your point's very well taken. The French, in an effort to get rid of hijabs and so forth, banned all religious garb. So that includes yarmulkes, it includes turbans, it includes even a veil that doesn't obscure the face. All of those are impermissible in French public settings. You can't be employed by the post office and wear a kippah if you're a Jew. Why? Makes no sense. Well, to French thinking, laicism, the principle of laïcité, is a strict separationist approach between religion and the state. Well, is it? No, that's nonsense. My kids in France went to Catholic school funded by this, in part by the French government, where there are crucifixes on the wall. The European Court in the Lauzi decision just determined that Italian schools can have crucifixes throughout under what's known in European law as the margin of appreciation, respect for the Italian way of doing things historically. So secularism isn't as clear as it may appear, and we have these ways of accommodating religious difference. The Canadian Marriage Act allows religious officials not to marry same-sex couples. Why? Because Canada doesn't homogeneously apply principles. It has contextual difference, and that's really important. And that's what's being missed in Trinity Western.
Hans, you wanted to dip into this.
I was wondering if you could respond to a view that many proponents of gay sex might hold, and that is the idea that whereas you made a distinction between racism and homophobia, perhaps some of these people who are proponents might suggest they're actually not so dissimilar. Or in fact, perhaps to be gay is as much to be black or to be white or to be brown or to be straight. Does that point make sense?
Well, no, that's how they are. That's how it's argued. Is
So how
that
do you
you're?
respond?
Well, I would say it's inaccurate. It's an inaccurate analogy because what's being rejected isn't the fact that you're gay per se. It's what you're choosing to do sexually. They don't accept the distinction between your desire and your right to act on your desire. They don't accept it for heterosexuals. You have to understand this. To go to Trinity Western as a heterosexual person does not give you the right to be sexually involved at Trinity Western.
Right. So I agree.
Now there
on
is a
that
distinction, and that is that, and this can be made, that you can be married as a heterosexual and go to Trinity Western, but you can't be married as a gay person and go to Trinity Western.
point. Yes, and that's where I would focus this point.
Yeah, but the issue there is the cost of that versus the cost of getting rid of associational diversity in Canada. In other words, there's costs involved, and they're huge costs. And is the cost of requiring Trinity Western to not have a law school outweighed by? There's no evidence whatsoever that any gay couple has ever applied to go to Trinity Western. This is entirely. Now, I imagine that part of the strategy, if I was advising gay activists, would be find a gay couple to apply there, make sure that they're out and proud, make sure that they're in the face of Trinity, make sure they go to the press and make a real stink about being a gay couple.
And that they're evangelical. And that they're
Yeah,
evangelical.
make it. They're
Yeah.
evangelical Christians. Really tighten the
This could be
screws.
done.
Tighten the screws on Trinity Western. Now, why would you want to do that? Because you want to get rid of Trinity Western's view on sexual conduct. See, I want to take it back to that because that's the issue. What's really at issue is sexual conduct. It's been dressed up as identity for the sake of argument, very cleverly linked to racism, but it's a fake argument.
So let me
It
raise
isn't real.
Let me raise something. Just can I build on this?
If you like, yeah.
Oh, go ahead.
I was going to build on it as well. You make a I think you separate very much desire and conduct, and I think you'd suggest that there's an entirely free will between those. So, in other words, if I'm gay or not gay, if I have sexual desires in either case, I have an entirely free will to pursue those desires or not pursue them, and it's in the extension from those that Trinity Western and others have, that's where those moral principles lie.
Well,
in terms of
they view human beings as being capable of making acts of the will in relation to desire. Yes, they do view that.
right.
Now, if you don't accept that, then what do you do with desire for another person's spouse? Whether you're gay or not gay. What do you do with fidelity, humanly speaking? What do you do with pedophilic desires? What do you do with beastophilic desires? What do you do with the panoply of desires sexually that people might have? And people are weird. They choose all manner of coupling if they can do it, right? What do you do with that? Now, this isn't to denigrate sex, by the way. Sex is great and it has a wide variety of expressions. But we have all kinds of restrictions culturally about adultery, which will apply to gay couples now. If you deny the will in relation to sexual desire, as a gay couple, what's your stance on fidelity? And there's a lot of jealousy in the gay community. They have the same problems of, can I trust you? Don't I? You're being a slut, as every couple does. So they're not free of this issue of desire versus the will either. The problem is that kind of claim is not being analyzed in our cultural discussions.
But-
Did I address your concern?
No, you're addressing it. I'm just trying to push it.
We'll keep pushing.
Go ahead.
Push
well,
away.
maybe this pushes it. There is a is there within the mindset of Trinity Western, the people that have shaped that, is there within their understanding this idea that sexual attraction is only and always a choice?
I don't know the answer to that. But let's look at it.
Yeah.
If that was in their thinking, where are you going with the question? What
Well,
do you think
what
the
I'm asking-
consequence is?
I mean, there's in the debate that schismed the Lutheran Church and the Anglicans recently. I talked to people on both sides of that throughout that process, and I was very struck by a number of things. But one was that there was part of the one group of people within that debate, and a group of people that certainly would be considered by the others to be homophobic. They argued that being gay or lesbian is a lifestyle choice. Always and only. That it is, they rejected the notion that somebody could be born with almost the sole desire for conjugal relations with the same sex. So I always thought this was very curious because
Are these people, I mean, not that it's the determinant of your question, but are the people saying that gay or straight, to use that?
they're straight,
Okay, now what if they were gay making the same argument, because they exist?
making the same argument, making the argument that it's always a choice.
Yeah.
Yeah. Well, I know there are gay people that have argued that. I mean, I think they've just lifted that language actually from part of the gay community. But here's my point.
Yeah.
My point is that, you know, next to the brain, I suppose, the sexual dimension of our life and our biology is certainly one of the most complicated things in the being of a human. And since when we are conceived and come to be as womb children and then are born into the world, obviously there is so much variety in the human family. The idea that a person that people would not be attracted all along the bell curve. The idea that on the far ends of the bell curve, you have people who are flaming heterosexuals and people who are flaming gays. The idea that that is not something that is, in a sense, within their biology, that it is simply an act of will or choice. And my sense is that in this particular constituency of people, they did not appreciate what it would mean to be on the end of the bell spectrum, where you were fundamentally and solely attracted to the same sex.
And to live in a world where with that attraction, you're rejected for
Right.
it.
Yeah.
See, because as I said earlier, and I want to make this really clear, nothing I'm saying is a rejection of the valid claims
Right. Yeah.
that there are unjust discriminations against people on the basis of their sexual orientations. I think there are unjust claims, which is why I think we need laws to protect gays and lesbians and others. I believe that. But this discussion is a different discussion. This discussion is about the limits of the claims of gays and lesbians that other associations not be allowed to have full public rights. That's what this is about, in my view. So we're demarcating here the limits on the claim that other groups should not be able to teach what they want to teach about sex. On the way here, David and I were talking on the drive on the highway about the idea that there's one kind of moral conception about law, and that's represented, or that the moral conceptions of law are adequately represented by Canadian law schools at the moment. That really worries me, because I don't think that the average Canadian law school experience adequately deals with morality and law at all, in my experience. And I was a professor at a Canadian law school in last January, visiting professor at Western. The kind of legal environment is dominated, as Berger said, by a very narrow spectrum of liberal opinion. And it doesn't have a lot of time for religion. That worries me, because religion really matters to
It doesn't
culture.
have any time for religion.
It hates it. And by and large, to be a religious either a religious academic, if you can find them, means you have to keep your head down. It means you're often subjected to discrimination. You can't get your articles published. There's evidence for all this. I know of leading minds in Canada who cannot get their legal articles published here. They publish in other countries because of discrimination against their viewpoints. Not their competence as academics. It's because their viewpoints run into the ideology that is now dominant in Canadian law schools. The kind of ideology that I criticized in the Law Dean's letter. That Law Dean's letter should have received widespread criticism from within the law schools. It didn't. There was a courageous law professor who wrote a few letters about it. In discussing him with a very well-known advocate just a few nights ago, I was told that the joke was how it was put to me in the law school, was that he should be the dean of Trinity Western. In other words, there was no courtesy extended to this superb academic's viewpoint because he was religious. Turn it around and imagine if he was gay and that was said about him. In other words, it's fine to be anti-religious now in Canada, but it's completely unacceptable to be perceived as homophobic. Well, what's wrong with this picture? Well, what's wrong is we purport to be a diverse society that accepts a variety of opinions, but increasingly we're not. The rhetoric of equality is used to affect inequality for communities like Trinity. The rhetoric of diversity is used to affect increasingly homogeneity. And the rhetoric of non-discrimination is used to affect discrimination against groups like Trinity Western.
But in Ontario, when there was some talk of having Sharia law recognized for the adherence of that community, there was a great public backlash, and I don't think it went anywhere. Isn't that giving religious freedom to a group of people within the law that our idea of homogeneity cannot accept?
Well, it depends what you mean by Sharia law. I mean, the thing is, the Sharia law is a great red flag. No one really knows what aspects of Sharia were being legislated for or against. We already have.
What they were asking for really was that Sharia law, as it relates to the family and inheritance,
And women's rights.
and Sharia courts could have some kind of legal standing, the same kind of legal standing that First Peoples sentencing circles have.
Or
That's where they got the idea, or Jewish dim Torahs,
or
the
Catholic
Roman
marital
So
tribunals.
it's exactly the same as that, and the province of Ontario then said, oh, no, we can't do, I mean, because it was a hot button issue because of the way Sharia is understood in the press these days.
And your example from France is the case. So we can't have Sharia, so guess what? Now we'll roll it back for all the other
For all the
communities.
others. So
And who wins
none of
in
them
that?
have any standing.
Well, who wins in that now? Well, who wins in that is secularism, which always has and everywhere has wanted to marginalize religious associations and privatize religious rights, individualize them.
The lady that wrote Infidel talked about Netherlands, and she said the Netherlands government should not allow Islamic schools because there was such terrible oppression of women and children in the Islamic society, and that would only be encouraged by allowing children to not attend the public school. And that would be an example then of taking away this homogeneity, going against homogeneity, letting free expression reign. And she was very much, well, she's still a Muslim, she was very much against having Muslim schools.
Yeah. Well, let's look at that for a minute. Is it an either or is it an all or nothing proposition? The funding of Muslim schools. Does that mean we lose control completely over the curriculum? No, doesn't mean that at all.
If you don't fund them, you lose control.
Yeah,
It wasn't funded, it was private schools. But
Yeah.
she was against.
But that's the
but so you see, here's the thing. If you're going to allow private schools that are largely free from the review of the state and its curriculum requirements and its monitoring, et cetera, et cetera, et cetera, and you're concerned about radicalism and non-assimilation and viewpoints that are anti-cultural for the rest of the society, would you rather work with those people or just allow them to be in silos, immune from review by the rest of society? I know what I'd choose. So then the question is, how do you get to an evaluative, appropriately cooperative model? Well, it isn't by saying, you guys stay over there and have nothing to do with our systems. It's actually an invitation to dialogue. And that invitation can take the form of, let's talk about the kind of schooling that you want funding for. Tell us what you want, and here's our requirements. And the requirements for education, it seems to me, need to focus at some point on the idea of civic virtues. What are the virtues that should be common to be involved in the civic sphere for all citizens, religious, atheist, agnostic? We're all in it together as citizens. What is the moral curriculum of our public system? Answer, no one knows.
Zippo.
Because we've become metaphobic. We're afraid of metaphysics. As a culture, we run from moral articulation, which is why we've replaced it with this meaningless language of values. George Grant, the Canadian philosopher, once put it brilliantly like this in an interview with David Cayley. He said, values language is an obscuring language for morality used when the idea of purpose has been destroyed. Say it again, it's a profound insight, really important insight. Values language is an obscuring language for morality used when the idea of purpose has been destroyed. Now, we don't know what our purposes are anymore as human beings because we've privatized the whole search for meaning. Who used to teach about shared purposes? Answer, different kinds of associations in society, particularly religious associations. They talked about the need to have, that there was a purpose in life. They taught that the universe had meaning, that we were somehow in a relationship with a loving creator. I mean, all the different religions have their own language for this. But in order to be in that relationship, we needed to inculcate certain principles of what? Compassion, love, honesty, integrity, etc. We called it the Decalogue, 10 Commandments, all these in the Jewish and Christian traditions. Other traditions all have their moral codes. Contemporary education has slipped into values language. Why? Because you have your values, I have mine. That's proposition one. What's the second proposition? You must not enforce yours on me or push yours on me. That's values imperialism. In the second proposition of a values framework, you don't do that. So what does that give us as a moral framework for a culture? Canadian values. Great. What are they? It depends who you're talking to. Are you talking to, let's take an issue, abortion. What are the Canadian values in relation to the issue of abortion? Depends entirely who you're talking to. Are you talking to the National Association of Abortion Rights Activists? Or are you talking to somebody from a pro-life Catholic organization? They're both Canadian. In other words, the language of Canadian values is precisely meaningless, but it's become the dominant political language. The value the language of charter values, which the judges use and lawyers use, is meaningless. The language of family values is meaningless. Anything with values attached to it is subject to this deep ambiguity that we do not know what we're talking about. So Grant's right. It's an obscuring language for morality. And guess what? It's the dominant moral language, pseudo-moral language of our day. And that shows very, very graphically the problem of our contemporary moral discourse in our languages. It's a profound insight, Grant, and others have shared. And understanding it should lead to a recovery. And not just recovery, because we need to think afresh about what we mean by civic virtue. Because virtues aren't just what you want. It's what you are in relation to an objective moral category. Justice is a cardinal virtue. Wisdom, courage, moderation. And the three, what the developed Christian tradition in the West called the theological virtues, which are inspired, the faith, hope, and charity. And they perfect, those three inspired virtues, perfect the natural virtues, justice, wisdom, courage, and moderation. That little discussion that took, 2 minutes on virtues versus values is shared across all the religions, and it's shared by thoughtful atheists and agnostics. And it should be the basis of our public education, and almost nobody knows it. So we have values. That's a culture that is in full drift ahead. And that's us. It can be changed, but it can only be changed against a vision. And the vision is the clarity of, partly the clarity of expression. And the recognition of which communities contain the framework that can articulate that richer language. And it isn't going to be driven primarily by law, nor by politics.
I want to come at the Trinity Western thing in a different way.
Yeah.
And just see what people think of it, and then we have to wind this up. I've wondered about when I first heard of Trinity Western wanting to do this, I kind of shook my head and said, "Oh God, why are you bothering with this?" And I knew the two people who were involved in the initial study and in raising the money and what have you. So I had an opportunity to talk with them at length about this. One of my arguments to them was, you're going to have to raise how many, $100 million or something to get this off the ground properly. And you will spend 95% of that replicating what is done at the law school at UBC. Why would you do that? Why would you want to raise that money? Because it's a professional school, so there are professional standards, and they're all alike, so that you could spend 5% of the time. Would it even be that? 10%? Would it be that? I doubt it. Looking at whatever is distinctive around your belief system and your understanding of cases in Canada where religion is an issue. Instead of raising $100 million for a law school and spending 90 or 95% of the time replicating what the public does, why not raise a quarter of that amount and have an institute which focuses on what you really care about, which is these cases, if that's what they really care about, these cases where religion is an issue, the sort of things that you've been involved in for years, and bring lawyers, law students, judges, people who are interested in a regular way for in-service work to deepen their understanding of those matters and also to do what you can to seed within the legal community a greater capacity to engage these issues. So what do you make of that?
No, I think it's great. I think it's great, but in the face of what we're talking about as a secularized kind of dominance of legal education, that has the risk of leaving the engagement with the law entirely outside of the academy, quote unquote. Now, another alternative might be to take a page out of history and look at the idea of funding chairs in specific existing universities, chairs that have a particular ethos. Chair, for example, for the study of law and religion. The risk there is, can you find the candidates that teach it from a perspective that sufficiently interrogates the model that I've been describing as problematical? But assuming that you can get a chair funded, because most universities won't say no to money as long as it comes, relatively free of, corporate.
But they're pretty careful about these matters.
They are. So you may in fact not be able to find a law school that would want or welcome such a chair. Then the only alternative, if you can't have a university, faculty, new, like Trinity, if you can't have that, or can you have Trinity without its covenant? Maybe that's another alternative. If the problem with Trinity's program is its covenant, then maybe they need to rethink the covenant. Because I'm sure there's no one at Trinity who would object to teaching gay students, and they probably have been teaching gay students. And I probably think they would agree they've been teaching gay students. And I know for sure there's been gay students who've gone to Trinity, and some of them have publicly said they found the experience very good. They didn't feel picked upon there. So there's all these questions. But maybe Trinity has to rethink its understanding of what it is that makes Trinity Trinity. And maybe it isn't just the covenant. Maybe the covenant has there's some other way. I'm sure they've thought about this. But so then David's question about an institution, a kind of think tank or a framework, a set of symposia and so forth, I think that's a good one. I don't think it's an either or. I think that idea of having a set of programs designed to backfill this gap that we're describing in education and in law, I think that's not only doable, I think it's important.
Chester Running Center can take it on.
Yeah.
Pardon?
The Chester Running Center
Oh,
can
yeah.
take it on.
David Grove for president.
No
Yeah.
problem. No problem.
Are there any pockets of hope?
Sure.
What are some of the
Well,
pockets of hope that you see developing around this whole discussion?
Well, there's analysis amongst some of the academics that is being honed by these challenges. In other words, I think we're in a different place now culturally than we were 20 years ago in terms of the rigor of the analysis of the problems. For example, the fact that now people are starting to issue articles about the nature of the secular, this really analyzing what we mean when we refer to a country being a secular country. I think that's very hopeful, because for a long period everybody just assumed that secular meant non-religious. Well, wait a minute, if secular is medical ethics, public education, and government, and religion is outside of all that, then isn't religion sort of put in a closet? And so a lot of people started thinking about secular and saying, well, wait a minute, secular didn't used to mean non-religion. It meant time, as opposed to, secularum was time rather than eternity. Time in relation to eternity. It wasn't desacralized. The shift in the meaning of secular occurred in the mid-19th century. So this new way of thinking about secular as stripped of religion is actually a problem. We need a richer understanding of an inclusive secular sphere. Well, that dovetailed with the thinking about public being inclusive, as I said earlier, from the Big M Drug Mart decision. So that's hopeful, that we can take the key concepts of contemporary culture, public, secular, secularism, secularization, the public involvement of religion, and we can start to re-articulate it and think of it in new and engaging ways. I find that very hopeful.
There's another area I would point to, Agnes, this movement towards a liberalism that brings everything together, a totalizing civil sphere, I think is in its last, is having its, I think what we're witnessing here is part of its death throes. And the reason is this: it is Muslims and it is Native people. The First Peoples communities in Canada have got on their feet. There's a long way to go, but they have some wind in their sails, and they have some ground that they have gained. And that, if you are, as in the case of the tribunals and the Sharia law, there isn't a politician around that's going to apply this to them. Like, what's going to happen now in Winnipeg, where the Native community has said that we are going to enforce our criteria on who has Native status and who doesn't. And all of you people who've married outside the community have to leave, which is in the works. You have to leave by December, the spring or something like that. What's going to happen around that? And what's the politics around that? How's that going to work? So my sense is that one of the signs of hope that you're looking for is that there are some communities of people who care about their difference, or put it another way, they care about their culture in a way which has enough glue in it and enough traction on the ground that this is the beginning of a conversation. This is one of the big conversations of the 21st century, sorting through this. The other two partners in it, and I think we will see in it historically, in my view, or at least I've thought this for years, is Quebec, because it has gone the route of the so-called secular. It has defined itself and it has political power as a coherent unit with a shared history. And the fourth one, and maybe the first one in our part of the world, I think is the women's movement. And the women's movement made enormous arguments about the distinctive ways in which women know the world, the distinctive things that need to be taken into account, as well as issues of equality. But they did both, not just one. So my sense is that those four areas are areas which are making this kind of conversation and this kind of thinking absolutely necessary. And it isn't sorted out, and it won't be sorted out for a while, but it's on the books. It's happening. And frankly, 20 years ago, I was very depressed about this because I didn't think it was happening at all. And I really think diversity is fabulous. Viva la différence. And it's the anthropologist in me thinks that's one of the real treasures of life, is to meet those you do not understand.
And learn what you differ about and what you have in common.
Yeah.
I think it's this requirement to get deeper than just difference
Mm-hmm.
that is really going to be productive of a new openness to moral articulation. Because we live in a very interesting time when we have, at the same time, movements that use deeply moral ideas like justice and discrimination, equality. These are deeply moral notions. We hold that on one side, and on the other side, a real fear and reticence to deal with right and wrong as a moral concept that can be taught. So I think the fact of the contradiction between these two things could lead us towards a requirement of the necessity to bring them closer together. And my own choice has been to opt for a richer language of virtues rather than values, and to look now increasingly at this concept that's really not been worked on much recently at all, civic virtues, as a means of learning how to educate about citizenship.
One of my concerns in that area, Iain and I have talked a lot about it, is something we've done here at the Ronnie Center a bit. I wish we could do more. Is to cultivate within religious communities a knowledge and understanding and a capacity to access the theological and spiritual teaching within those traditions about their responsibility for the civil life. Because so much of the conversation that's gone on has been between a religious community that sits here versus what they see as a secular group over here. Well, various Christian traditions and Islam and Judaism, Hindu, Buddhist traditions, various traditions, have spent some time, some more than others, actually thinking about what constitutes the civil life, and have some things to say about that. But it's not part of the conversation very often. So this initiative of the International Ronnie Center Fellows is one way of trying to pull that forward, to have the kind of men and women who have that depth of knowledge and have the ability to speak publicly, so that where there's a conversation around significant matters that we need to think through within the public sphere, we have the best of thinking from all quarters instead of just the worst from two quarters.
The other thing, the other sign of hope, and I think it's very, very interesting, and I think we're at the beginning of it, is to recognize the limits of law and the limits of government as a means of understanding what is left. And what's left is variously described as civil society. And civil society or intermediary institutions, whatever. But civil society is the third aspect of culture that's been largely ignored. And to the extent that law and government have expanded beyond their proper jurisdiction, those aspects of culture that are intermediary, the family, civic organizations, and so forth, are denuded. Their pressures put on them, they're reduced. Yet they alone contain the capacity to do the kind of moral, rich articulation that I was referring to earlier. In conjunction with associations, you can have a richer conception of how we live together. If the work of civic engagement is done between the religions, not contra government, not against government, but extra government, outside of it, then you have a whole different dialogue. It becomes a trialogue between law, government, and civil society. And that whole third dimension is new. And I think, based on the work we did in South Africa, that the creation of a civil charter with the religions doing it with help, but basically with assistance, coming up with a charter of religious rights and freedoms right across the spectrum, from African customary religion all the way through. Catholics, Protestants, Jews, Muslim, Judicial Council, all of them signed this charter. It could not have been done by government, but it was done by people working together. Now the goal is to roll that document out, make it well known. But here's the interesting side effect of doing it. These groups now know each other. They've worked together. Didn't require government to do it. They did it themselves. I think we could do it in Canada. I think we could do it in other countries. And I think this move is possibly an epoch-making shift, because human cultures have, for lots of historical reasons, come into this situation where the primary drivers of everything has been government action and law. But those are singularly inept at developing the richest concepts of civic virtue that we've recognized as essential. So this freeing up of civil society to work around key concepts could be huge in the future.
One of the ways of doing that is instead of giving so much voice to celebrating diversity, let's celebrate commonalities that bring people together,
What we share.
what we share.
The preamble to the South African Constitution is interesting. It says, whereas we are a people united in diversity. I like that because it holds together. This is my paper this afternoon. What divides? It's just funny you raise that. What divides is the recognition of pluralism and diversity. What unites is the recognition of the common good and civic virtue. And who decides? That's the key one. Is it going to be? Is the decision about how all this works the law's decision, or is it something more subtle and more interesting? And what does it look like? Because we're so used to trying to settle our disputes in court. But as Charles Taylor, the Canadian philosopher, has pointed out, litigation is not the best means of achieving consensus. You get a
worst.
You get a winner and a loser, right?
Would deliberative democracy play a role, or an alternative? Is that something that you considered in thinking about this third civic
I think,
domain?
well, it's not thought through. So, I mean, I think yes. I think the reform of the systems we have. I mean, if you just look at voting numbers alone, particularly if you bracket them by age, we're facing a crisis of democracy. Democracy's capacity to say that it's the will of the people is becoming more and more thin as the people don't care. They don't vote. As the young say, this is all a joke. These people are not dealing with the issues that really matter. Why would I vote? Gives credibility to this charade, you know. That's not my viewpoint, but that's how some people articulate the problem. So voting numbers are dropping. Some countries, like Australia, have tried to deal with it by making it an offense not to vote. So they force you to vote. I'm not sure that necessarily correlates to being informed about the nature of what's at issue. But clearly, two-party politics is funded by big business, you know, where there's lack of restriction on who supports, is not the best way of reaching the kind of nuance that most issues require. So I think we do need, as you're suggesting, alternative approaches to what we understand as democracy.
And can that civic domain be institutionalized, or would that inherently destroy it again?
Well, again, I don't think it's an either or. I mean, so many of these questions admit of possible divergence, different applications. I would like to see civil society start to understand itself as having a role in forming sets of principles that have interpretive influence on judges and on politicians because of how they've organized themselves around it. In other words, so many people speak in favor of a particular approach or document that the politicians can't but take notice of it. You know, and that's how mass movements, think of Solidarity, for example, in Poland. That's how mass movements ultimately influence government, because government can no longer resist them. Like what's going on in Hong Kong is extremely significant. And all of these things, Martin Luther King, you know, Gandhi, all of these mass movements, many of which emerge from different insights from religion, they speak to power in different languages, but they're a language that ultimately is something can't be ignored. And I think I would, if there's a sign of hope, for me, it's that we think about new ways of coalescing opinion to influence those who have decision-making ability.
C'est ça? Thanks so much. Thank you, Iain.
Thank you.